I'm Dylan Nolan here for FITSNews, and I'm very lucky to be sitting across from Jack Swerling today. You're one of South Carolina's most esteemed defense attorneys. You've been doing this job for a very long time, and everybody who I talk to in your profession has nothing but great things to say about you, and I've had the pleasure of getting to know you a little bit over the last couple of years as I've worked my way into the media space here in South Carolina. There's a number of legal matters that we've been covering here at FITSNews that you've been peripherally or directly involved in. I guess the biggest thing, everyone saw you this week sitting there at Alec Murdaugh's attempt to get a retrial. What are some things that you noticed watching those proceedings?
Well, the proceedings that took place last Monday, I was interested in it because I wanted to see the arguments on the motion for a new trial. I was familiar with the arguments that were going to be made and, what I think the intention was by Harpootlian and Griffin to what they were going to present. And, sort of familiar with the response was going to be from the Attorney General. So I really wanted to sit there and don't get the opportunity much to watch other lawyers handle cases. So this was of interest to me, and that's why I wanted to be there. I think that, the big thing is going to be coming out of Monday's hearing and the denial of the motion for a new trial is, what the standard that's going to be used. And I know Murdaugh's lawyers were arguing that there should be a presumption of prejudice by the mere contact by the clerk of court with the jury, and that would raise the presumption of prejudice under Remmer. But Justice Toll went ahead and went with the Green case, which was an opinion written by Justice Kittredge, which said that the presumption doesn't apply in every case, and they would have to prove prejudice. And so that's what she relied on, and she came to the conclusion that they did not prove prejudice. And a lot of that was based on really solely on the testimony of the jurors. Because if the jurors had come forward and said they were prejudiced or influenced by Becky Hill and returned a guilty verdict based on that, then you would be getting a new trial.
And it's interesting because Justice Kittredge is likely to be Chief Justice Kittredge by the time that this case makes its way to the South Carolina Supreme Court. So her interpretation of his ruling could, he could have the opportunity to directly look at his ruling and say, was this interpreted correctly?
Yeah, he would certainly look at Green and he would look at Remmer. Of course, they addressed Remmer in the Green case, but I would not expect that his opinion would change any, because that opinion that he wrote in Green is not that old. So it's going to be interesting to see. I mean, a lot of people look to Justice Toll as, one of the great legal minds in South Carolina. So I think it's going to be interesting to see how it comes out. But there was a record made. She really let in a lot more than I think everybody thought she was going to based on the pretrial hearing. So I thought it was quite interesting. Personally, I was looking to see what the jurors were going to actually say when they got to court, because there were affidavits, there were interviews, but until someone actually gets placed under oath, you really don't know what they're going to say. And so I think everybody was looking to see what they would say in response to her questions, particularly juror number Z. Or letter Z.
Right.
She had indicated in her affidavit that she was pressured by the jury during the deliberations and came out with a guilty verdict. I think that the Harpootlian and Griffin would like to have seen her say that she was also influenced or pressured by Becky Hill's comments and actions, but it didn't come out that way. She did testify to that, but it was not what was in the affidavit. So based on those inconsistencies, what I understand is Justice Toll did not find that her verdict was based upon what Becky Hill did, but what on the jury deliberations and the pressure she felt from the jury, which you're going to have in every case. Jurors are going to be swayed by what other arguments are made by jurors. And that they're supposed to deliberate and they're supposed to listen to each other and come out with a verdict. So I don't think that she thought, or in fact she didn't think, that was the prejudice that was necessary to get a new trial.
Yeah, and I don't know how many states the case would win if jurors weren't allowed to speak with one another and attempt to reach a unanimous verdict.
Yeah, and I think a lot of jurors, they may go into deliberations one way and they listen to the other jurors and what you're supposed to do. I mean, you're supposed to consider what everybody's saying, what everybody's, viewpoint is of the evidence and the law in the case. But sure, there's going to be pressure in almost every jury's deliberations. And some jurors are going to feel like they were pressured by, not necessarily that you have to come up with this verdict, but what the opinions of the other jurors were as well.
And that's the reason, if a jury's having a hard time reaching a verdict, the whole process is geared towards reaching a verdict to the point where the judge is going to say, okay, well, we're not going to put our hands up yet. I'm going to deliver you this Allen charge. I'm going to direct you to go continue deliberating, i.e., to me, this slants towards a state where you're saying, all right, those of you who feel you can reach a verdict, here's your opportunity to continue to speak with those who can't. And obviously, at the end of that process, if you still have jurors who aren't willing to deliver a guilty verdict, then we have a mistrial or maybe all not guilty.
Right, and that's what when they do give the Allen charge, which we call the dynamite charge in the law. It's basically don't give up your individual opinions or what you really believe, but listen to the other jurors and consider what the other jurors are saying and try and reach a verdict. And the Allen charge is given when the jury's been deliberating for quite a while and they have not been able to reach a verdict, or they come out and report that they have not been able to reach a unanimous verdict. So the judge gives the Allen charge to go ahead and say, look, this case is going to have to be tried again by another jury from the same backgrounds, and there's no reason to believe that they're going to have any easier time. So, go back, don't give up your honest opinions and what you think, but listen to the other jurors. And I think that's the purpose of it. Most of the time when they get an Allen charge, they come back with a verdict under those circumstances.
Now, you've tried many a case. What are you thinking, and what is your client usually thinking as a defense attorney when that's going down in a courtroom?
Well, I mean, the Allen charge, I kind of, when I hear that the jury's not been able to reach a verdict, everybody tries to speculate as to, which way the jury's going. Yeah. But, it really is still no way to know because you don't know what the count is in the back, and you're not allowed to know what the count is. In fact, the judge will tell the jury that, I don't want to know what your count is. So, sometimes I do believe when we hear that there's going to be an Allen charge given, that, it's favorable that the jury is divided and, they're listening, they're talking about the evidence. And so obviously there's some people on that jury who have not been able to reach a verdict, are finding not guilty as well. So it at least gives you a hope that, there's a ray of light at the end of the tunnel.
Something else that I know that you've experienced in your legal career and that we saw in the Murdaugh case that I think was very interesting is a client who doesn't want to listen to his attorneys. And Dick and Jim were very clear before Alex took the stand. They were kind of washing their hands of it for the public, for the record, And when Alex took the stand, we saw why. It was disastrous for the defense.
Right.
What do you do as an attorney when you're somebody who, quite frankly, I don't think there's much better that money can buy as far as representation, and yet you have a client who says, I think I've got a better way of doing this?
Well, I take a good bit of time with the client, and explain to him the consequences, the pros and cons of getting up on the witness stand and testifying. And, I want the client to ultimately make that decision, but I think it has to be an informed decision as to what the consequences could be and why I think that either the client should take the stand or why the client should not take the stand. And I think that's what lawyers are required to do. So give the client enough information so that he understands where you're coming from as the lawyer and what you see are the potential upside and downside, and then let the client make the decision himself. The unique situation in this case was that the client was a lawyer who had quite a bit of trial experience. And so he had his own perspective about whether or not he should take the stand or not. And obviously he took the position that he wanted to take the stand. I'm sure that was based upon his own personal experience trying cases in front of a jury. And, it probably was not the right decision on his part for a number of reasons that everybody got to see. And I don't think it helped him to taking the stand at all. There were too many questions that he could be asked on cross-examination, as we saw, that their answers were not going to be particularly good in his favor or not looked on favorably by the jury. And plus the other thing is not only the cross-examination that's done, but how the client himself is going to appear in front of a jury. There are clients that come up and get on the stand, and they are able to convince a jury and look at the jury and be able to convince them of their position in the case. And then there are clients who get on the witness stand, maybe be a little cocky, may not be sympathetic, empathetic, may not convey that to a jury. But that jury is looking at that person throughout the trial, but then particularly when they get on the witness stand, they're really looking at that individual and assessing whether that individual is telling the truth or not. And so you are putting yourself in that position when you get up there that the jury really is going to scrutinize whether or not you're credible or not, and whether or not your story is consistent with what they understand the evidence to be. So it's a big risk. I've tried many cases where we have not put the client on the stand, and I think people think, well, if they don't hear from the defendant himself, that they're going to look at that as a negative factor. That the defendant did not take the stand. But juries are amazing when they listen to the law, when the judge gives them the law. And I've had a number of acquittals where the client has never taken the stand, and we just rely on the burden of proof that the state did not meet and argue to the jury that they have not met their burden of proof. So it's really a mixed bag. I mean, there's just no way to know for sure. If the client is acquitted, then you're a hero. If the client is not acquitted, then you looked at, well, did you make a mistake or did the client make the mistake? So I will give my advice, but it's going to be based upon what my perceptions are of how that defendant's going to be on the witness stand, how I think he's going to come across. Is he a warm individual? Is he a cocky individual? Is he a cold individual? Is his story consistent? During the trial prep, how do I feel that the individual has done during the trial? During the pretrial preparation, and how he's going to do during the trial. That's what I meant to say.
It's interesting. I was very recently in the Lexington County Courthouse where I was called for jury duty, and I ultimately, the defense attorney didn't want me. The state would have taken me, but I made it that far in the selection process. But
well, that's pretty good.
Yeah. But the defendant turned around. And,
I'd put you on the jury.
Well, thank you, Jack.
Okay.
I would give your client a fair shake. I can promise you that. But as soon as the defendant turned around, his attorney introduced himself, and the client, like you say, it's that impression. And the jury obviously was in that room. They had not been seated yet, but I didn't think that was a good sign for his client. Just on the first 30 seconds of having been aware that this is the man who's being tried. And I had to call the court back, throughout the week just to make sure that they weren't going to schedule something else that they needed me for. And I was curious. I asked the clerk at the end of the week what happened on that murder trial, and he was convicted. And I do think that, that impression that you leave as a defendant, I don't know whether he took the stand or not. I didn't follow the trial after my obligation as a juror ended, but it's interesting because a client of yours that I reported on, Greg Leone, his murder trial, he took the stand, and I find Greg very likable.
Yes.
And I guess that's the impression you got preparing with him. I mean, I can even understand why he committed the crime that he was convicted of committing, but he took to the stand, and I believe he basically explained why he did it, which maybe for posterity, for the public record, is something that he felt he needed to do. And I think he's an honest individual who just thought, okay, I'm going to get up there and bare my heart. But ultimately, Solicitor Hubbard was able to compellingly convince a jury that that was violative of the law.
Yeah, I mean, he's one of the individuals that I really had no problem putting on the stand. And certainly there was nothing in his background that I was concerned about that would have come out during the course of his testimony. I mean, he was very likable. I mean, had a million friends. Everybody liked Greg from all walks of life. Everybody I ever talked to who knew him liked him. And so I wasn't really concerned about that. I think that when he got on the problem that when he got on the witness stand, some of the testimony, I think the jury found not credible. And based on his version of what happened and why he did certain things. And that's unfortunate because I think that there was a story to be told there which would have explained or did explain why he did what he did. I just don't think it came across that way to the jury. And that's unfortunate because I really don't think Greg had any kind of ill will. I don't think he had an evil heart or anything like that. It never appeared to me that there was any way that a jury could come back and find that there was malice on his part. But it's the way he came across in the testimony, and Hubbard did a good job on the cross-examination, and that's just something you don't know until somebody actually gets on that witness stand, takes that oath, and starts testifying. So, I was disappointed in that case because I thought Greg had a very good defense in the case. It just didn't come across that way to the jury.
And it's interesting because there were points that he stuck to that, honestly, only he could have known, that there wasn't hard facts corroborating, as that I think had he chosen to not talk about, which nobody could have proven him wrong on, he might have had a better chance. But he stuck with his guns.
Yeah, he did. And I think that the big factor there was I'm not sure the jury ever bought into the fact that he put the tracking device on his wife's car because he thought she was involved in drugs. And, if the jury determines that something is not credible, if somebody's not telling the truth about one issue, they may not be telling the truth about the other issues. So, I mean, I thought that was, one of the big things that the jury may have come back and decided to find him guilty of the murder. I was quite surprised, that they came back with murder. But, it's like you said, people look at somebody when they have a chance to observe him on the witness stand for a couple of hours. They make an assessment, his credibility and his likability and whether he's telling the truth or not. And so you're taking that chance when you get on the witness stand. I thought he was going to come across pretty well, but I was always concerned about that issue.
I think he did come across well, but I take your point that, that drug angle, and that's what I'm saying. Only this was what Greg was thinking in his mind. This is not something that the state could produce evidence to disprove. If he didn't go down that path, because as I was reporting on this trial, that was immediately what set off my BS meter against the defendant, because I'm thinking this just doesn't make any sense, and surely this is what the jury is perceiving as well.
Right, and I think that's what the jury determined. I mean, because the facts as to when he went out there and he went into the parking lot, I think were pretty much in his favor. As far as what actually happened in the parking lot. The question is why was he in the parking lot? Why did he go to the parking lot, and how did he know to go to the parking lot? And so the jury, I think, looked at that testimony, and I think they questioned. I think that was the big question they had on their mind. That's just my assessment of it. That they just didn't find that to be a credible explanation. But as far as what actually happened at the truck, I thought what he testified to made a lot of sense to me, and would have made sense to the jury as well.
So same solicitor, maybe the same courtroom, maybe even the same judge. I think Lexington County has 2 circuit court judges, so 50-50 is the Lindler case. I don't know if you're familiar with this at all, but it's another self-defense case out of Lexington County, and the facts don't look great for the defendant in that case, who it's a father and a son. They're over.
That's the new case that
right.
one's pending now.
Right.
Yeah.
Is it Eric Bland's involved?
Right. Yeah, I've tried a lot of self-defense cases in Lexington and a lot of battered women cases. That was something I tried, a number of those back in the 80s and 90s. And the county you want to be in when you have a self-defense situation is Lexington County, because people there truly believe that a person has a right to go ahead and act in their own defense or in defense of somebody else. I think Lexington County is one of the best counties in the state for that. But it's not a great county to try a case in where self-defense is not an issue, and because they take the law very seriously there, and they take their oath very seriously. But if I have a true self-defense case, that's where I want to be, Lexington County.
Yeah, and I might have sounded like I was beating around the bush as I was posing that question, and obviously I want to let the facts come out in court, because right now we just have what parties or their attorneys are saying in the media, so we got to wait and see how things shake out in a real court of law. But just based on what you're saying there and what I've seen in Lexington County courthouses, on my own, that might be a rough shake there for the Lindlers.
Well, my understanding is that the defendants were at the victim's house. Is that, or am I mistaken about that?
So I believe that they live on the same street, and the victim was over at the Lindlers' house, maybe giving them a hard time, and then I think the Lindlers retrieved a gun and went over to the victim's house. But I don't want to get this wrong, so please don't quote me on that.
No, that's fine. I just it seems to me I just remember that that's what happened. It was at the victim's house, and they had gone over there. But I could be completely wrong about that. I haven't followed it very closely, but I know which case you're talking about.
Now, this is maybe a bit of a coy and basic question, but if you were to advise somebody how to not become a future client of yours, should they shoot somebody if they don't have a gun? If the person you are shooting does not have a gun, should you shoot them?
Well, under the law of self-defense, which goes back a couple hundred years, you have the right to act on appearances. So if you believe somebody has a deadly weapon,
and this is what you argued in Greg Leone.
Correct. And and we spent a lot of time talking about basically appearances, what it appeared to be to Greg Leone. You're entitled to rely on appearances. You're entitled to rely on your past experience with someone, what kind of individual that is, their character, their reputation. But that is something, the appearances in the law is a really big legal principle. And so you can rely, if you believe, even if you're wrong, if you believe that someone is armed with a deadly weapon, you have a right to act on appearances, even if it turns out that that person did not have a weapon. Obviously, it comes out a lot better, and a jury is going to be a lot stronger in your favor on self-defense if he turns out to have a weapon. But that is not required. It's whatever it appears to be. And, some famous cases in South Carolina where somebody thought somebody had a weapon. I'm trying to remember the name of the case, but it was involved, the editor of the state newspaper was involved in a shooting way back at the turn of the century. And the individuals there believed that he had a gun and shot him. And so it turned out he was acquitted of self-defense. I'm trying to remember if it was what his name was. I can't remember. Gonzalez, I think, is what the case was. But he did not have a pistol, and he was shot and he was killed. And he still was found not guilty by reason of self-defense.
Well, as a newspaper man myself, I don't know that I quite like that. But
no.
As somebody who's I'm actually taking my CWP test this weekend. I guess that's a good thing. However, I'm going to endeavor to use my handgun in such a way that I don't need to retain a defense attorney at any point in time.
No, I don't want you to have to either.
Yeah, I prefer talking to you as a friend and as a source, not as a client.
Right.
Another thing that you've been vocal on that we cover is judicial reform. You were invited to testify before the House Ad Hoc Subcommittee, which was impaneled to provide recommendations to House leadership as they look to put together some sort of judicial reform bill. And it's interesting. I'm kind of operating under the impression that they brought you in there thinking that you would maybe bolster the current system as it is and testify that things are working well, just based off of some of the people that I know that are behind the scenes over there. But you basically came in and testified that there's a problem in South Carolina, and I don't want to put words in your mouth, so I'll let you explain it.
Yeah, I mean, I think the current structure of the Judicial Merit Selection Committee has lawyers on there that are defense lawyers who practice in the criminal courts. And so I have a problem with that because the judges, and I'm not I have no names to give, and I can't. All the judges I'm aware of, are highly ethical and are not. I don't believe would be influenced by that, but it gives the appearance when a member of the House is sitting on the Judicial Merit Selection Committee, and they appear in front of that judge, but they also have the option of whether or not to elect that judge or not. And so that gives me some trouble. That it certainly gives out the appearance of impropriety, not on the judge's part, but on the lawyer-legislator part, that he is sitting there appointing or electing judges, and he's also appearing in front of judges. And I don't like that. I think that when individuals who are looking for a lawyer, a lot of them look for somebody that they know has helped elect judges. And so they're going to those particular lawyers as opposed to other lawyers who are not in the legislature, and they select the lawyer based on that decision alone, that lawyer is a representative in the House and gets to elect the judges. So I don't like that system. I'm against that system, and I think it needs to be. I gave some suggestions, that limit the number of legislators on the Judicial Merit Selection Committee, limit their terms so that they don't appear, or judges don't have to appear in front of them every 7 years when they come up for election. It should be maybe a 2-year period where they're there, so they don't get to select that judge several times. It would limit any opportunity for anybody to think that there was any impropriety or appearance of impropriety. I'd like to think that our judges and the judges I know would not be influenced, but I think that the public perceives that lawyer legislators can influence a judge, and so that's what bothers me also.
And it's interesting. My background is actually, I have an accounting degree, and the way that I think of systems is that if it can be broken, if it can be manipulated improprietously, then it's safe to assume that eventually it will be. And I think that, you don't want to point to a specific judge, a specific example, and I completely understand that as a member of the bar, somebody who's appearing, before judges. And I think we've seen it being broken, but I think the fact that the system can be broken is enough of a reason.
Well, and again, I don't know any judge that I think that would be influenced, and I certainly, in 50 years of practice, I don't criticize judges at all. I have to appear in front of them, and the ones that I know, many of them I know well. A number of them were my classmates from law school over the years. But it's the perception, and it's also it's the public perception. And the fact that they think some of the people in the public who are charged with serious crimes, they believe that a lawyer-legislator has some influence with a judge. And that's also what bothers me, because I think that what it's doing is putting the lawyers who have a lot of skill and a lot of experience, it puts them at a disadvantage. So it's a dual kind of thing that I look at. It's not only the lawyer-legislator, it's not the judiciary, but it's also what the public's perception is.
Well, and quite frankly, if I'm being charged with a serious crime, let's take away the JMSC and say that the judges are appointed in a completely different way. I'm going to look at somebody who gets a get-out-of-court free pass for a large portion of the year as somebody who I'd be willing to pay more an hour.
Right.
You mean they're just going to be able to prolong the case, assuming that I might be facing the rest of my life in prison? If you can delay me going into prison for 2 or 3 years because they can't get me in court, that's 2 or 3 more years of my life that I spend in the free world.
Yeah, and they have the legislative immunity. So
that's what I'm speaking about, obviously.
Right.
Yeah.
No, I know. I understand. And that is a factor because they can delay the case, 5-6 months. Whereas, I, who am not a legislator, cannot delay it on that basis. Now, it takes a while to get into court anyway. But they have judicial immunity, and that there's a period of time when the legislature is in session that solicitors cannot call the case. And Hubbard, and I saw that day I was there. I saw Rick Hubbard there. I saw David Pascoe. I saw Kevin Brackett from up in New York, And they were there, and that's one of the problems they have in the case. It slows down their docket. They can't call cases to trial. And so some of the lawyer legislators may take advantage of that legislative immunity by not wanting to appear in court, whereas I would have to appear in court unless I had some other legitimate excuse.
And you mentioned the solicitors, the prosecutors that are pushing this. It's interesting to me, anytime I'm looking at a story and I see people on one side of the coin have something to say, okay, what's the other side? Prosecutor, to hear the same thing coming from a defense attorney, and a very reputable one, to me illustrates that this is not just the prosecutors pushing for more power. This is a broader problem.
Yeah, and it is. And they have, I've spoken to the solicitors about it, and I know the ones that were there, I think there were like 12 or 13 solicitors who really were together on this issue. And they don't like the fact, the way they have to go ahead and call their docket, that it's based upon judicial immunity. Not judicial, I'm sorry, legislative immunity. And so they can't call these cases to court. And, look, like anything else, sometimes the system is abused that way. And there may be some lawyer legislators who are abusing it. But if you listen to the solicitors, that is what they're concerned about, is it being abused.
Right. Something that has come up in the process, and this is actually something that ad hoc committee was tasked with, which I think has kind of taken the back burner to the circuit court, to the JMSC. And to me, this is unfortunate, because this is where the majority of South Carolinians who are facing some sort of legal problems are going to be, is magistrate court reform. Do you have any opinions on how the magistrate courts operate and what might be done to improve them in South Carolina?
Well, they operate a lot better today than they did when I started practicing, because back in the day, prehistoric times, it was even you didn't have any educational requirements. I mean, there were people who were magistrates who just were selected, average working guys or women who, mostly guys, who became magistrates. There's their political connections. And today, we have a lot more experienced people, a lot more educated people sitting as magistrates. And, when you think about the fact that you're administering justice, you want people who have, some educational background, can understand the legal principles involved, understand the constitutional issues involved, and, can be fair and impartial. So the system has gotten quite a bit better since I started practicing back in the day in 1973. And, there were, I remember trying cases in back of gas stations, where the magistrate, ran and operated a gas station and, took a period of time during the day to go ahead and try a case. And, those were interesting, and various places you had to go where the magistrate, had a job, but it was, part-time a magistrate. So there were a lot of interesting situations that developed in those days. But it's a lot better today. I think the magistrate system, people don't realize how many cases they actually moved and handle. And they're really essential in South Carolina, the magistrates court. And most of the magistrates I know are, try to do a good job. But it still is very, they're appointed by, I believe, the delegation.
The Senate delegation.
Yeah, Senate delegation. And so there's still some politics involved in it as to who gets appointed. But I think it's a much better system today because of the minimum requirements to go ahead and be a magistrate.
Yeah, I can't really get over the idea of somebody coming up, Your Honor, may I put $15 on pump 2?
Hey, let me tell you, there were some interesting situations back when I started. Some of the magistrates I appeared in front of, I remember asking for a jury trial once in North South Carolina. The trial took place at the top of a firehouse next to a city dump. And so during the summer, there were mosquitoes all over the place, and we had to take our jackets off. It was so hot, there was no air conditioning. And I remember at the end of the state's case, I moved for a directed verdict, And the magistrate said, "Mr. Swerling, you asked for a jury trial. You're going to get it. I'm not going to give you a directed verdict in this case," which is totally, had nothing to do with the case. They're supposed to direct a verdict if there was no evidence. And in that case, there was no evidence. But the judge kind of got annoyed with me because I asked for the judge to go ahead and direct a verdict of not guilty in the case. So it's gotten a lot better.
Well, obviously things have changed a lot. You're somebody who's seen it all. What's your advice to somebody maybe my age who's beginning a career in the legal profession?
Well, I can tell you what I did in the beginning. I mean, I did a little bit of everything for the first few years when I started practicing, and I was very fortunate to practice with State Senator Isidore Lurie, who was at that time one of what they called the Young Turks. There was about 5 or 6 of them that were very progressive, very liberal, wanted to change a lot of the system in South Carolina. And I was fortunate to work with him. He was a terrific guy, and he's my mentor, and he's really responsible for whatever I've accomplished over all these last 50 years. He taught me a lot. But I really enjoyed doing the criminal work, and I just found dealing with those particular kind of problems and the people that got involved in those situations. I just enjoyed that kind of work, and I enjoyed the jury trial work. And that was where I had the opportunity to try a lot of cases. And so I spent a lot of time in the courts. I observed, I was around, I would go down to municipal court in the morning with my clients, just meet a lot of people and just get my name got known. I wanted to be there. I wanted to be seen. I wanted to be visible. So a lot of my practice developed out of that kind of system. A lot of it was the magistrate's court in the beginning. When you're a lawyer just starting out, you're not going to get the big cases, but you have to start. You have to start somewhere, and that's a great place to start. And I got to hone a lot of my skills in the magistrate's court when it's a little bit more informal than it is in general sessions court or in federal court. So I had a chance to hone whatever skills I had to see what worked and what didn't work. And so I would encourage, young lawyers to go ahead and still do that. Go to the magistrate's courts, be seen in the magistrate's courts, handle magistrate court cases. And then I also advise people to get involved in community functions, get to be known by people, join different clubs, different societies so that your perspective and the people you meet come from all walks of life. Because I think lawyers have to be good judges of character. They have to know people from all walks of life because they're going to be appearing in front of those people trying cases. So I think it's a combination of things, getting the experience. Go sit in the General Sessions Court or in the Court of Common Pleas. Watch other lawyers try cases and look and see what you think works and what doesn't work. I'm the type of person that, I enjoy people. I enjoy being around people. So that's been something that I've learned over the years by going to courts, being involved in different groups, church, synagogue, social clubs, whatever it may be. And so I have a different perspective about people that maybe other people don't get by not exposing themselves to those kinds of situations. So I still do that. Once in a while, I love to sit in a court for a few minutes and just see what's going on, see what other lawyers do. I just don't have that opportunity that much. That's why I was there Monday. I wanted to see what my old partner and Jim Griffin and what the other lawyers were going to be doing and observe them. I'm always willing to learn. I continue to learn.
Well, thank you so much for taking the time to talk to me. I always really enjoy our conversations.
Sure. Same here. Same here.